Good afternoon. I'm Alex Colvin, the Public Programs Curator at the Alabama Department of Archives and History. Welcome to this virtual History Now program on tribal sovereignty and the Supreme Court. Today, we're going to be discussing the recent landmark Supreme Court decision in McGirt v. Oklahoma, which was reached on July 9th, 2020. Now, in the simplest of terms, the Supreme Court's decision was about the territorial boundaries of the Muscogee Creek Nation, the sovereignty of the Muscogee Creek over their citizens within those boundaries, and defining the proper jurisdiction for major criminal cases within their territory. We'll be discussing the case in detail momentarily with our panelists, but first, I'd like to address a question. What's the Alabama connection? Meaning, why is the Alabama Department of Archives and History dealing with a topic that is current and seemingly pertains to the Muscogee Creek and Oklahoma? Well, first, this case revolves around the sovereignty and borders of the Muscogee Creek Nation, whose ancestral homeland encompassed most of present-day Alabama, Georgia, and northern Florida. The very name of our state, Alabama, comes from one of the tribes of the historic Creek Nation. So to know about the present circumstances of the Muscogee Creek Nation is to understand their history and ours. Second, this decision is the continuation of a long conversation between the United States and the Creek, as well as many other Native American tribes. In 1790, the newly formed United States negotiated their first treaty with the Creek Nation. In that year, Creek delegates traveled from their towns, which sat in present-day Alabama and Georgia, to go to New York City to talk directly with Secretary of War Henry Knox and President George Washington. Now, this treaty had multiple articles and purposes for trade, peace, diplomacy, and assimilation. But it also affirmed two things. Within its borders, the Creek Nation had sovereignty over its land and citizens. And as a sovereign nation, it would deal directly with the federal government of the United States and not the governments of states, of individual states. In many ways, these are the same questions that we are still answering in the McGirt decision. Over the next 40 years after the 1790 treaty, roughly a dozen more treaties were signed that gradually ceded Creek territory to Georgia and Alabama until the Creek were subjected to forced removal in the 1830s. They, along with the Chickasaw, Choctaw, Cherokee, and Seminole, were removed to new territory in the West on a journey called the Trail of Tears, so called because of the mistreatment, dislocation, and death of thousands of Native Americans. The treaties that led to this removal promised that this new home would be secured forever, but over time, this promise was also broken. In writing the opinion of the court, Justice Neil Gorsuch said that this decision was meant to uphold the promises made on the far end of the Trail of Tears. The purpose of our History Now programs is to understand the connection between our past and present. And today we will see how history informed the decision of the Supreme Court. With that said, I would like to introduce our panelists. First, I would like to introduce Jonodev Chaudhuri, who received his JD from Cornell University Law School. He currently serves as the ambassador for the Muscogee Creek Nation to the United States, but he previously served as Chief Justice of the Muscogee Creek Nation Supreme Court and Chairman of the National Indian Gaming Commission. Second, I would like to introduce Grant Christensen. Professor Christensen holds a JD from Ohio State and an LLM in Indigenous Peoples Law and Policy from the University of Arizona. He's an associate professor at the University of North Dakota Law School, where he teaches courses on federal Indian law and jurisdiction in Indian country. He also sits on the Supreme Court of the Standing Rock Sioux Nation. Welcome, gentlemen. How are you both today?
XG. It's an honor to be with you today, Professor.
Thank you. Well, I'd like to get started on some questions about this case. First, I'll start with Professor Christensen. Can you provide us with a brief overview of the McGirt v. Oklahoma case and explain why this case was brought forth before the Supreme Court?
Sure. I'll try to be brief, although as in so many things in Indian law, right, the history is never quite as short as maybe we'd like it to be for those like 10-second sound bites. The McGirt decision actually goes all the way back to another case, Carpenter v. Murphy, which was set for oral argument during the 2018-2019 term of the Supreme Court. And a lot of persons might have come at this case, if you've heard about it, through the Murphy decision, right? A number of podcasts started maybe a year ago kind of previewing the plight of Mr. Murphy. And Mr. Murphy is a Muscogee citizen who was convicted in state court of a murder that occurred while on the Muscogee reservation or within its boundaries, but on land that wasn't owned by the tribe or its members. And so he was prosecuted by the state of Oklahoma. He ultimately challenged that decision, saying that as an Indian person, the appropriate charges should be leveled by the United States federal government under the Major Crimes Act, instead of by the state of Oklahoma, the state not having jurisdiction in this area in what we call Indian country, which includes the reservations. The 10th Circuit Court of Appeals initially agreed that the reservation, the Muscogee reservation, was not diminished. And so Mr. Murphy's conduct occurred within the boundaries of Indian country. So the state had no jurisdiction over him. This was in direct conflict with a number of decisions of the Oklahoma State Supreme Court, which had found the reservation to be diminished. And so the US Supreme Court only takes, say, 80 or so cases a year, right? Why does it take, this case? And it takes it because there's a clear difference of opinion in the interpretation of the law between the Oklahoma Supreme Court and the 10th Circuit. And so that's why we have a Supreme Court, to resolve these kinds of differences in interpretation about the law. And so the Supreme Court takes the McGirt opinion, or the Murphy opinion, but Justice Gorsuch has to recuse himself. He was a judge on the 10th Circuit Court of Appeals, and while he never heard the case on the merits, he participated in a decision not to hear the case en banc, to have the entire 10th Circuit not review the decision. Every justice has their own way of determining when they recuse themselves in Supreme Court cases, but the threshold is really high so that we don't have any perception, right, of inappropriate conduct. So with Justice Gorsuch recused, the Supreme Court deadlocked 4-4 on the Murphy opinion. And so they ordered it, instead of deciding the case, they ordered it for re-argument. And this doesn't happen very often. The idea of the court deadlocking is really very unusual, although it's happened 3 times in Indian law cases since 2016. While then we were waiting for re-argument, the court granted cert or agreed to hear a new case this last term. And that new case is McGirt. So you can see where the origins, right, go back, and it's a little bit more complicated. By granting the McGirt case, which raised the same legal question, Mr. McGirt was prosecuted and convicted by the state of Oklahoma courts for a set of crimes that occurred on the Muscogee reservation. And Mr. McGirt is himself an Indian. So he made the same argument. The Major Crimes Act says the federal government and not the state should have the ability to prosecute me. But this time, Justice Gorsuch did not hear the opinion as a member of the 10th Circuit. And so he was able to sit and review the McGirt opinion in a way that he was unable to hear or had recused himself from the Murphy opinion. And so because the case ends up deadlocking 5-4, Justice Gorsuch becomes that all-important voice, right? He breaks the 4-4 tie, right? 5-4 in favor of the interpretation from the 10th Circuit that the reservation has not been diminished. And that's a little bit of its origin story. Yeah.
Oh, you're right. It's very complicated history, but especially an important one to try to understand. So, Ambassador Chaudhuri, I have a question for you. It has multiple parts to it, so bear with me. The first is that in both the arguments of the counselors and an opinion of the court delivered by Justice Gorsuch, the Treaty of 1832, the Treaty of 1866, and the allotment period were all mentioned. Can you briefly tell us about those treaties and allotment period, and also their places in the arguments of the McGirt v. Oklahoma decision?
Thank you, Professor. And again, it's an honor to be here. I'm happy to discuss that, but let me just talk very briefly about what this case means to me personally and many Muscogee, meaning Muscogee people, as well as Native Americans throughout this country. Beyond the technical legal implications of this was a ray of hope that despite a history of broken promises, the Supreme Court, through intellectual rigor, was willing to do the right thing. Now, I'm happy to get into the details, but that resonates certainly with Creeks throughout this land, but that idea resonates with Indian people across this land. So it was an intellectually robust opinion. It was a powerful opinion, prose bordering on poetry, but prose grounded in law. And what those prose essentially say is that despite a history of deprivation through treaties, but also through bad actions by state actors, by local communities, the court is willing to not be outcome determinative, but to do the right thing based on the law. And its application of solemn to this case is a striking example of doing the right thing despite great pressure from many folks for the court to be outcome determinative, to find a way to say that our reservation has been disestablished. So the fact that we aren't erased in our own home is critical in terms of understanding the importance of this case. I also want to take a brief moment to say thank you for having me on. Alabama is close to my heart and our nation's heart because it is our original homelands, Alabama, Georgia, and northern Florida, but especially so for my family. My family is an Upper Creek family. My family comes from tribal towns in the Okmulgee area, Fish Pond and Arbica and others. And we were moved along with Lower Creek towns as part of the Indian Removal Act that came on the heels of some of the earlier treaties that you mentioned. In a nutshell, all those treaties stood for one thing. It stood for our nation doing everything it could in light of these major demographic forces to preserve its sovereignty and its ability to determine its own future. But each of these treaties in their own ways have been broken over the years, were basically entered into with varying degrees of duress. Almost all of them resulted in huge swaths of land being ceded for these promises. And at each stage, despite all these demographic forces, at the very least, there are these promises made by the US government that our nation, like so many nations throughout this land, had hoped the US would honor. The history of the federal government's willingness to honor those treaties is checkered at best. And as we know from history, but also as reflected in Justice Gorsuch's opinion, the state didn't have the same view of what the United States commitment was. And that's why we have a history of illegal prosecutions that had been taking place. But those treaties do stand for one thing. Despite the fact that they were forced upon our nation under great duress, they do contain promises in exchange for those cessions of land. And it was a ray of hope to see Justice Gorsuch uphold that promise that lied at the end of the Trail of Tears.
Definitely. It was something that in our history we see so often. Like you said, these promises that are made and then broken, sometimes immediately, sometimes over a longer period. And it's great to hear from the perspective, also not just the historical perspective or a legal perspective, but also how your community remembers these different periods of time.
If I could add, I should have added, again, another reason we're so honored to be here. Our homelands are in Alabama, the heart of our homelands, and the heart of one of the mother towns, the great mother towns that many of my towns came from, is Hickory Grounds. And for us, that's a powerful notion. My mother's umbilical cord is buried where she grew up. And that's a very Creek tradition to bury your umbilical cord at the heart of your homelands. For us as Creek people, our collective umbilical cord is buried in Alabama. And that is the source of, you know, our history, but also our culture and tradition, which remains alive and strong today. So again, thank you for having me.
Oh, thank you for joining us. We're very happy to have you here. And so we can kind of see that all these treaties are used both in the legal arguments, but in the decision to help uphold this notion that there are promises that were made that need to be affirmed by the government because they were never broken. They are not legally broken. They were broken in every other sense, but not through the legal means. And that is what Supreme Court has decided. But Mr. Christensen, or Professor Christensen, can you please expand on that? What is the decision of the court, and what the legal ramifications does this have?
Sure. So the decision of the court is a recognition that the Muscogee Reservation has never been diminished or disestablished, that the entire thing, even though some of the land is now owned by non-Indian people, even though some of the land was open to non-Indian settlement, that the entire thing is still an Indian reservation, is still Indian country, over which, right, the Muscogee may continue to exercise their inherent powers. And so one of the narratives that I've been frustrated with as a legal scholar that's come out in the media is this idea that the Supreme Court gave the tribe something, right? That the Supreme Court, you know, gave the Muscogee a reservation. And that's of course that's the complete opposite of what happened, right? You know, even the word reservation, right? The land belonged to the native persons to begin with. They ceded their interest to other lands and reserved those lands kept, right? That's where even the origin of the term reservation comes from. And so the recognition from Justice Gorsuch and the court is not a gift to the tribe. It's a recognition that the land has always been reserved by the tribe as its homeland, or as its, you know, over which it may exercise its sovereignty, right? And of course, homeland in this case is more problematic, as we've just heard, right? The original lands of the Muscogee lie elsewhere, but that this land is the land reserved by the nation for its own use and independence. And so, you know, just like I may, as an American citizen, go buy land in Canada, right? So may a non-Indian person end up buying fee land, right, in the Muscogee Nation. But that doesn't mean that the nation ceases to exist. And this narrative that's come out in a lot of the media from the case that the Supreme Court gave the tribe something is just, it's bad reporting from journalists, right? It's because what the Supreme Court did is they recognized the reservation has always been there. And so what that means for persons like Mr. Murphy and for Mr. McGirt is that their crimes were committed by Indians in Indian country, and under well-established legal doctrines, the state has no authority to prosecute those crimes. And so, you know, going forward, you know, the state is without the inherent power to prosecute crimes involving Indians that occur anywhere on the Muscogee Reservation or anywhere within the Muscogee Nation, right? And so persons like Mr. Murphy and Mr. McGirt are going to be entitled to new trials that take place under the Major Crimes Act in a federal court, and or trials that take place under Muscogee law, under Muscogee courts, right? That an Indian who commits a crime in Indian country is subject to the jurisdiction of the tribe and is subject to the jurisdiction of the United States, but is not subject to the jurisdiction of the state of Oklahoma. And so persons like Mr. Murphy and Mr. McGirt will win their arguments that they should be released from state custody, but that doesn't mean that their crimes go without punishment, right? It just means that the entity who punished them needs to be an entity with jurisdiction over the land on which they committed their crimes. And so we'll have a trial that takes place in a federal court and or a trial that takes place in Muscogee court, and those individuals will be duly punished accordingly. And Justice Gorsuch was clear in his opinion that not every Indian who's currently in a state facility may choose to contest their jurisdiction, right? They may serve out their sentence and then be released. We may end up, or we will by necessity end up with a lot of plea agreements where federal prosecutors come in and agree to plead out to similar amounts of time, right, without having to go through the rigors of a new trial. We may end up seeing some Indian persons released a little early as a result of the opinion, depending on how Oklahoma and their petitions with Oklahoma courts go. But overall, it's not going to radically change the use of law enforcement, right, on the nation. It's just changing who does the prosecution. When you get picked up and you're charged with a crime, if you're an Indian person, the state should turn you over to the tribe or the United States. And what will likely happen at some point is what's happened with Indian tribes across the country. There'll be a political consensus where the state of Oklahoma and the Muscogee Nation enter into some kind of agreement to cross-deputize each other's law enforcement officers or to deal with jurisdiction. But the opinion gives the Muscogee Nation the upper hand. And so hopefully it has the ability to determine what is important for the nation when it sits down in order to work out how are we going to deal with law enforcement in Indian country. And the opinion may have other implications for civil jurisdiction and all kinds of things, but I'll stop here, right, for the sake of, well, brevity, but not. Thank you for indulging me.
And if I could add to that, an excellent summary Professor Christensen gave. To build on that, our nation, through our principal chief, David Hill, announced yesterday that it's forming a commission to address these very issues. It's forming a commission with both external and internal functions. Principal Chief Hill noted that this commission will be made up of Creek citizens, but part of its function will be to engage in outreach to intergovernmental partners to address cross-deputization agreements, tribal state compacts, informal agreements to address these very issues. And so we're building on the fact that over 40, I think something like 45 cross-deputization agreements already were in place at the time that McGirt was decided. We're building on that. Regardless of what transition issues may be, the idea is that through intergovernmental collaboration, we'll build a more prosperous future for all. And so this idea that there's chaos that needs to be fixed, as some commentators have presented, I couldn't agree with Professor Christensen more. The sky is falling narrative is not helpful because our nation has a long history of working with other nations. And this is the time to be focusing on addressing these opportunities together. The Supreme Court brought clarity to the jurisdictional landscape rather than chaos. And with that clarity, now Creek Nation as a sovereign entity can more effectively roll up its sleeves with other sovereign entities for the betterment of all. And so it brought clarity, not confusion. We know what reservations are. We know how reservations work, and we know the potential for positive economic development for tribal members and non-tribal members alike, as well as how reservations work with tribal nations work on their reservations to address public safety. And that's what we're doing.
And Justice Gorsuch, in his opinion, points out to the state of Oklahoma, look, this might be a new situation for you, the state of Oklahoma, but Tacoma, Washington has been dealing with this, Mount Pleasant, Michigan, Green Bay, Wisconsin, right? This idea is not unprecedented that even large numbers, large communities of non-Indian persons may sit in or abut Indian country without excessive problems, right? Phoenix has reservations on 3 sides of it, right? And is a much larger city than Tulsa, and yet is able to go ahead and make the arrangement work. And so it takes a little bit of political will and compromise, which Oklahoma has been unwilling to do up till now. And I think that the ambassador's right that the Supreme Court decision helps to clarify the issues for all the stakeholders. And now that we understand that the reservation isn't diminished, we can move forward, we can get rid of the politicking, and we can move forward and talk about the compromises that we're going to make. How does the nation and the state of Oklahoma as joint sovereigns work together? The same way that Oklahoma has to work with Kansas or Texas or Arkansas, right, on its borders, right? We enter into these kinds of agreements. This isn't a kind of sky is falling narrative. It's just this is what politicking and what governance is all about. And those decisions and conversations are going to move forward. And there are some really excellent models in other cities that Tulsa and the state of Oklahoma can turn to for how to make tribal state relations work really well, and in fact, open new opportunities to both tribal members and non-tribal members.
And absolutely, and I would add to that, and I know you've got plenty of questions, Professor, but just to build on that, having lived in Arizona for at various times in my life, anybody who lives in the Valley knows how well these intergovernmental cooperations work. Anybody who's shopped in the Pavilions area in Scottsdale knows that that's part of Salt River's commercial corridor, where you have large national and global chains engaged in commerce, benefiting tribes, tribal members, and non-Indians alike. And you work it out. One thing is clear: legislation's not needed at this time. The ink wasn't even dry on this historic McGirt decision when some voices called for a legislative fix. Well, if something's not broken, there's nothing to fix. This is an opportunity to build a more prosperous future for everybody within Creek Nation. To be sure, there are temporal transition issues that we're addressing actively, and we welcome intergovernmental cooperations. But over the long term, we see the benefits of natives and non-natives alike when folks work hand in hand. You don't need congressional action to do that. You need a spirit of cooperation. So,
and I love the discussions, and never apologize for y'all had a wonderful back and forth, and I enjoyed hearing it. But I do want to ask, you've already mentioned this a little bit, Ambassador Chaudhuri, but if you have anything you want to expand on it, what this decision means to the Muscogee Creek Nation and their future. But also, if you have a moment, we've already discussed some misconceptions that people, especially non-native people, have had about the decision. Are there any of those that you would like to address and clarify?
Yeah, well, I've heard on the ground quite a bit that some folks are very focused on the underlying facts of the case. And just to be clear, to build on Professor Christensen's comments, justice is the first priority of our nation. And part of our focus is to work as closely as possible with the U.S. Attorney's Office, local law enforcement, sheriff's offices, to make sure that public safety is priority number one. And as we address that, we'll continue building in the economic development space hand in hand with our business partners in Tulsa and elsewhere. We're back in Alabama and Georgia, and you're a historian, so you probably know this piece better than I do. There were feathers from South America in some of our historical remains. Parrots don't exist and never really existed in Alabama and Georgia, but those were a hallmark of the trade routes that we had that extended from South America all the way to Canada. Native communities are about building futures together, and we're pro-commerce. So anybody who understands the opportunities this provides in terms of jobs and resources for non-Indian interests will understand that this is an opportunity for a better future. And so we are first and foremost focused on justice. I'm happy to see that the U.S. Attorney's Office has brought high-profile cases. Our law enforcement and prosecutors are bringing cases themselves. And during this transition period, there is going to be learning that exists among all the partners. But that doesn't mean we should give up any long-term opportunities because of short-term transitional issues. Long-term opportunities, not just for Creek Nation, but for all within her borders. And the reason I keep bringing that up, there are some commentators that have called for legislation now, legislation forever. Give intergovernmental cooperation a chance to work, and let's reassess. If there are surgical things that need to be done that one nation or another nation wants to do, let's talk about that down the road. But that doesn't have to be done in the context of McGirt. Now, in the legal community, I can say that most Indian law legal scholars, and I would defer to Professor Christensen on this if I'm wrong, they're seeing this case as a Marbury versus Madison type of case. They're seeing this case as something akin to Brown versus Board of Education, something that should be placed in safekeeping and not be touched or diminished over time, because it's so important in terms of understanding the fabric of American history, which in our case goes back to 1790 when we negotiated the very first treaty, or one of the first treaties after the ratification of the new Constitution with George Washington. This goes back to the foundation of our history, not just as Muscogee Creek Nation citizens, but as American citizens. You don't mess with that for short-term challenges.
Yeah, in response, I want to talk a little bit about the effect of the opinion. Just, so the McGirt case isn't the first time the Supreme Court has talked about whether a reservation is diminished. In fact, in regards to the Omaha Nation up in Nebraska, we got a unanimous, an 8-0 opinion from the Supreme Court just in 2016 that the Omaha Nation was not diminished. And back in 1984, a decision that the Cheyenne River Reservation wasn't diminished. But we've had opinions that have diminished reservations. And one of the things that McGirt has changed is that up until McGirt, courts were looking not just at the language of Congress, right, at the treaties that were made and then the allotment acts, but they were looking at who moved on to the reservation afterwards. They were looking at external sources. In one case, in the Decatur case, in order to show that the Lake Traverse Reservation was diminished, they looked at some statements by bank officials, right? What does a private non-Indian bank have to do with whether an Indian reservation exists or not, right? And so one of the things that, even though the issue of diminishment is something that has come before the court very often, right? 5 times since 1984 and up to 20 times in the Supreme Court's history, the issue of how we interpret diminishment. Justice Gorsuch gave us some very clear language that we don't look beyond the language of the acts of Congress, so that we can't go ahead and say, well, this part of the reservation is now 90% non-Indian, right? Or it's lost its Indian character, a term Justice O'Connor liked to use when talking about reservations. And these are political entities, regardless of who's moved on to them, right? It's not about what was understood today in the nature of the reservation. It's about what was understood when Congress took its decision in order to allot or in order to deal with each of the reservations. And we say that we can only diminish a reservation if Congress's intent is clear and unambiguous. And so that didn't meet the threshold, right? And if we keep that test or that standard, it's going to be a lot harder for states to argue that reservations have been diminished. And Gorsuch made a really important point. He said, well, persons in Tulsa might be surprised to learn that they live in an Indian reservation. But Creek citizens in the 1832 would have been very surprised to learn that non-Indians, right, were living on, right, or believed that the land wasn't theirs, right? And we made binding promises not to the non-Indians that live in Tulsa in 2020. Our binding promises were made to the Creek citizens in treaties, right, in the 1830s and in the 1860s. And so it's these promises that the Supreme Court requires that we honor, because a treaty made with an Indian tribe is a treaty, and a treaty under the terms, the express terms of the U.S. Constitution, is the supreme law of the land. And so the expectations of non-Indian persons can't overcome the legal promises that are made in a binding treaty agreement.
Oh, do you have something to add?
Well, I mean, just this clear and unambiguous point that Justice Gorsuch made, that Professor Christensen mentioned, is critical, because there's another way to say that. It's that, yes, Congress does have the power to diminish or disestablish a reservation, but when it does so, it has to show its face to the world. So, Justice Gorsuch looked at the history of congressional action, which included these large-scale acts targeting assimilation, such as the Allotment Act, and said, that wasn't enough. That none of those acts, including Oklahoma statehood, none of those disestablished the reservation. That's an important point because back to this Marbury versus Madison idea, if Congress is going to take such incredible action and against these treaty provisions that had been entered into, it has to show its face to the world. And that's more important now than ever more. As I said before, there's a push by a very small group of folks who want to preserve the interests of certain, in all likelihood, certain special interests, and trying to roll back things so that the reservation doesn't fully exist. We have to be clear that if Congress takes action, it has to show its face to the world. It can't be in a midnight rider. It shouldn't be in a midnight rider. It shouldn't be something without full discussion of Indian country, and that's an important point.
One of our Facebook commentators has asked about whether Gorsuch's views in McGirt might be a shift in Indian law cases, or if he's a swing vote. And I'd love to take that one if that's okay, right? Yeah. Just the legal professor in me wants to answer that question, right? Wants to answer it so badly. So when Justice Scalia died, and then Justice Gorsuch replaced him, in a lot of ways, Justice Gorsuch's jurisprudence is very similar to Justice Scalia's jurisprudence, right? But in one really notable way, it's 180 degrees different. And that's his understanding of Indian law. And I think in the National Congress of American Indians, right, came out in support of his nomination. And it might be in part because as a justice from the 10th Circuit, he didn't come from the East Coast. He actually dealt with Indian law cases and saw appeals that were developed by tribal judges, right? And so developed a different understanding of Indian law in and of itself. And so he's been, a fifth vote on a number of 5-4 opinions in Indian law since he's joined the bench. But I don't actually know that makes him the swing vote. I think that he might be so committed to Indian principles that he's not the fifth vote you need. The fifth vote you need might be a Justice Ginsburg or a Justice Breyer, right? They might be the more swingy justices on Indian law jurisprudence, with Justice Gorsuch, when it comes to Indian law, being more firmly in the Justice Sotomayor, kind of Justice Douglas legacy of really understanding what tribal sovereignty is. And I think he'll end up writing maybe a disproportionate number of Indian law opinions because as a conservative justice, right, it's easier for him to kind of, write for a 5-4 or a 6-3 majority if he brings the more liberal justices with him. But also because I think it's clear from his writing, he feels something important about Indian law. I mean, even the way the opinion begins, right? At the end of the Trail of Tears, there was a promise, right? He has a treaty rights case, an opinion that he wrote on a tax issue out of Washington State a couple years ago, where he makes the point where Indian tribes have gone ahead and ceded such huge and valuable tracts of land that if we go ahead and we've given the tribe a promise in exchange that it doesn't have to pay state gasoline taxes in exchange for 50 million acres of land in Washington State, well, then that's a bargain at any price, right? And it's the least that the court can do to uphold those kinds of exchanges. His language has been so robust and protective of tribal communities that I think we'll continue to see him generally come down. He will not be the most difficult justice to persuade in future Indian law cases. And if we want to win 5-4 majorities, it won't necessarily be Justice Gorsuch and his understanding of Indian law. It's going to have to be, can we bring some of the more moderate Indian law scholars, right? Can we drag Justice Ginsburg or Justice Breyer along with us? For as Justice Ginsburg has been wonderful for the liberal movement on women's rights or on parts of the First Amendment, she really has struggled to understand what tribal sovereignty is, right? When individual rights and tribal sovereignty conflict, she has not always been a supporter of the Indian law or the Indian jurisprudence. And so, it's such an interesting alignment we're seeing. I don't know that Gorsuch is the swing vote, but he's definitely changing the balance on the court. And that was maybe longer than I should have taken. I'm sorry, but I just wanted to answer the question so badly.
Great to add, please let us know. But if any of our other viewers have a question you'd like to share, we have a little bit more time where we could ask our amazing panelists, our experts here, any questions you might have about the case. Ambassador, did you have anything you wanted to add about Justice Gorsuch?
Well, as I said before, to me, his opinion stands for it's the long-awaited intellectual rigor that we've needed to have applied to these cases. I mean, bottom line, there's nothing earth-shattering about applying the law, but it's applying the law despite the sky is falling narratives that had been pushed about what would happen if that was done. The intellectual rigor and the ability to be intellectually honest in taking these cases where the law leads you and really understanding the history of federal Indian law and the treaties. I think that is incredibly refreshing. I don't see him being outcome determinative. He understands the law better on these types of cases because of his background. And so I don't think in any way he's trying to get to a pro-Indian position. I mean, Indian law is historically and famously nonpartisan. Okay, it's nonpartisan and non-ideological in the sense that it's not conservative, it's not liberal, it's not Democrat, it's not Republican. But if you have an intellectually honest approach to Indian law, you'll understand the importance of upholding some of these foundational principles that relate to the nation-to-nation relationship between tribes in the United States. And so the intellectual rigor that was in place there is what, to me, as a recovering lawyer, but I also still wear my lawyer hat sometimes, that's what's the most refreshing to me.
Yeah. There's a question about the being able to reclaim land. And the McGirt opinion doesn't say anything about the restoration of land, but with a clear articulation that the reservation has not been diminished, individuals who own land in fee, so land that you've purchased on the open market and that you can sell to anyone on the open market, land owned by the tribe or by tribal members within the reservation is easier to be taken back into trust with the decision that the reservation has always existed. And so while that doesn't speak to the ability to kind of reclaim the land, the commentator indicates was wrongfully taken, and the rightfulness and wrongfulness are going to be so fact dependent and historical. McGirt has nothing to say about that. But it does indicate, with the reservation not being diminished, that if individuals own tracts of land in fee, they may petition either with the support of the tribe or on their own to have that land taken into trust by the United States, to restore that essentially to the tribal land base under a series of internal procedures adopted at Interior. And the decision in McGirt might make it a little bit easier for Interior to say yes, or to overcome some of the city of Tulsa or the state of Oklahoma or the county's objections to having land taken back into trust. And so while that doesn't speak to reclaiming the ownership of the land base, once it's owned, it may be protected in different ways because the reservation has not been diminished. But that's only if the owner of the land or the tribe itself wants to take the step to seek that protection.
And to build on that, immediately after the decision, we made the point that not 1 inch square of land changed hands in this decision. And there was just a lot of, as we've already mentioned, a lot of rhetoric out there that somehow land would be lost, or people can still buy and sell just as they did before. No ownership took place. And in terms of the administrative side of putting land into trust, having been an official at Interior before I was at NIGC, I served as senior counselor at the Assistant Secretary's office. There's a land into trust process, whether or not this land was determined to be reservation land. And so, the hope is that process will be streamlined a bit. But on the land side of things, not that much. I mean, really almost nothing changed. But there were people who ramped up the rhetoric, unfortunately, before going into the case.
One final question that I'd like to ask y'all. Can you comment on how the McGirt decision applies to the other tribes in the former Indian Territory, present-day Eastern Oklahoma, Cherokee, Choctaw, Chickasaw, and Seminole nations?
And thank you. So, those other tribes have similar treaties to the treaty that was in place that we entered into. And I think the prevailing wisdom going into the McGirt decision was that there'd be somehow a 5 tribes implication to the court. But the really interesting part of the case is Justice Gorsuch didn't hinge his opinion on the 1866 treaty by any means. It was instead a very thorough analysis of the congressional record, acts by Congress going back to allotment, the whole history of congressional action that was the focus. So it was very fact specific to Creek Nation. And so that means one of two things. If we're talking about the direct implication from the case to the lands in question, well, there was only one nation whose lands were in question in that case, and that's Muscogee Creek Nation. If you're talking about theoretical implications from the case, that's a much broader discussion. So while prevailing wisdom thought of this as a 5 tribes case going into the decision, I would suggest that you're either in for a penny or in for a pound. It's a exclusively Creek Nation case, or it's a case that all of Indian country needs to take a look at and frankly work together to protect and to preserve. This is an opportunity to collectively preserve sovereignty. And I think that's the lens that this should be looked at in.
I think it's really a blueprint for those who are going to challenge the diminishment of the other 5 tribes reservations, right? Because while McGirt doesn't decide the issue, it does give the legal framework, right? That in order to, the burden will be on the party wanting to argue the reservation has been diminished in order to prove diminishment. And the standard is going to be, did Congress clearly and unambiguously intend to diminish, right, when they passed those congressional statutes or acts? So the legal framework has been set, and it's created a high bar for those that oppose diminishment, but McGirt has not decided that the other members of the 5 tribes or any other of Oklahoma's 38 federally recognized tribes have reservations that have or have not been diminished. It's given us the framework. It's given us, here is the legal test, right? That presumption is the reservations are not diminished, but that was the presumption even before McGirt. And that the legal test is that it's going to come down to, did the statute enacted allotting each individual reservation show an intent by Congress to diminish the reservation or to disestablish the reservation? And so with that threshold, with that legal, there's a blueprint now for all of the tribes that wish to go ahead and put forward those arguments. But the Supreme Court case did not decide anything beyond the Muscogee reservation.
And thank you. And to build on that, as I said before, this is really an opportunity for intergovernmental collaboration. Some may say, well, based on that, don't we need Congress to come in and clarify? No, I mean, the gist of this is that nothing in Creek Nation's history disestablished the reservation. And so if there's that implication that comes from that, then there's nothing to stop any other tribe who has a similar argument from working with the state under that presumption. And you don't need Congress to come in and fix that. And so, there's a lot of rhetoric right now about the need for legislation. And I'm sorry I keep coming back to this, but there's so many red herrings in that line of argument. It's a little bit frustrating at this point, but the one thing that is clear is beyond the direct implications of the case, there is this understanding across Indian country that this is a case that needs to be protected and defended at all costs. I was very pleased to see that last week the National Congress of American Indians, to paraphrase their statement, came out with the statement that they will oppose any and all legislation that in any way diminishes the jurisdiction, sovereignty, and treaty rights affirmed in the historic McGirt case. Something to that effect. I mean, that is the right response right now. If there are surgical, things to take care of, that can be done outside of this rubric of changing McGirt.
I'm sad to do this because I could listen to y'all discuss this for many more hours. But it was about time to conclude. I want to ask if y'all have any kind of concluding remarks you'd like to make. But I will say, just as a historian, I would say that this decision in many ways is fulfilling, because you can see in every treaty that was ever signed or negotiated, the objective of the Creek was to maintain their sovereignty, was to protect that, was to protect their interests. And in many ways, finally, you hear coming from a branch of the US government saying, yes, that is something that we should also be upholding, and the promise that we should be keeping. And so I want to thank you, though, for expanding my knowledge on the case and expanding my knowledge on what it means both to the Muscogee Creek Nation, to other tribes, and to the United States. But do you have anything you would like to say in conclusion?
And thank you, Professor Colvin. Yes, if I may. And so this was a profoundly important case to me in my official role as ambassador. And I'm honored to kind of convey the messages from my leadership that I conveyed today. But on a very personal level, like so many Creeks, it resonated with me. Let me just explain one other piece to that. In addition to my legal background, I'm very engaged in our ceremonial world at Creek Nation. And while my bloodlines go to Fish Pond and Arbika, I, as an adult, joined the New Yaka ceremonial grounds. So I'll always have bloodlines to Fish Pond and Arbika. All these grounds go back to Upper Alabama, and were Upper Creek towns. But the town I joined, New Yaka, was named, it was a daughter ground of Hickory Grounds. It collectively changed its name in honor of this historic agreement that came out in 1790. Not in honor, but in recognition that this was changing the face of our nation. That's why our grounds are called New Yaka, short for New York, from the Treaty of New York. This idea that these agreements should be looked at in temporary terms, in terms of how folks might feel about the results at the moment, don't really give credit to the relationship of our nation to the United States that helped provide, integrity to the United States when it needed it most. In 1790, the United States needed to have legitimacy on the global stage, and they looked to tribal nations to do that. Ours was among the first, and that legitimacy helped build the nation that we exist in today. So as a member of New Yaka ceremonial grounds, whose lands are tied to Alabama, as well as coming from all these other grounds whose mother ground is Hickory Grounds. This is an important moment to understand that a piece of the American story, as well as an important piece of the Muscogee Creek Nation story, was affirmed in this historic case. So on a personal level, it really means the world to me that notion that we're not erased in our homes was upheld. And just Mado for this opportunity to speak with you today. It's been an honor.
Thank you.
And I would just say thank you so much for having me. My final thought is that opening sentence at the end of the Trail of Tears, there was a promise. That is going to be quoted to judges by persons advocating on behalf of tribes for more than a century. Right? That language from the court at the end of the Trail of Tears, there was a promise. Right? That idea is going to resonate. It serves as a wonderful kind of, it's a stopping point and a beginning, right? Because it stops those that want to constantly argue against or take away or revisit the history right? And with an understanding now that the reservation is intact, we can move forward and build something from there. And I just thank you for the opportunity. And I really love that if I had to, and end with a thought, I love that thought from Justice Gorsuch and Dr. Colvin. You previewed that at the very beginning today, right? Almost an hour ago. At the end of the Trail of Tears, there was a promise.
Thank you. And thank you to everyone who's joined us to watch. We're going to be have a recording of this archived on our YouTube page, so you could watch it and share it with anyone who think is interested. I know that many of you probably had questions that you did not get answered. If you want to forward them to me, I can connect you to Ambassador Chaudhuri or Professor Christensen so they can answer your questions. So thank you so much, and see you again soon, hopefully.
Mado.